it is for public. Maybe I don't feel it. So because I am an authority.
So you might dismiss it, they need not take cognizance of it, but you would not impose costs or punish a petition.
Smiling face, gentlemen, don't fight us like the petition. And next time you come on this, then we will take some other action on this. We can say so.
Right. Mr. Arora, before you go into the break, a quick reaction from you. The CGI and the Supreme Court has even talked of some guidelines to deal with the PILs. As a lawyer, as an advocate, do you welcome these guidelines?
The guidelines are already there, and I welcome those only to the extent that they will define the parameters. Otherwise, public interest litigation depends upon the perception of a High Court Chief Justice. I have dealt with 4 Honorable Chief Justices and 2 acting Chief Justices. Everybody had different perception. So perceptions may perhaps have lesser effect on the entertainment of PILs if the guidelines are framed. So we welcome it. We have no problem with the guidelines. But to punish, saying it is frivolous, ultimately what will happen? Such act cannot succeed. Ultimately the same honorable judges have to decide whether it is frivolous or not. They have to record a finding. If they come to a conclusion it is not frivolous, how the act will help? And if they are frivolous, then the High Court is already imposing fines in such cases. And take one more example. Writ petitions are also filed. Up to 30% approximately or 25% are dismissed on the very first day in the preliminary hearing. Right. Do we punish them? Do we convict them? Why only against the public spirited persons who are fighting for the country and against corruption? So this is politically motivated and frivolous litigation, I would say, frivolous legislation, I would say.
Frivolous legislation to check the so-called frivolous PILs.
Yes.
We'll just come back to you. Time for a short break now. When we return, we continue the discussion on whether there is need for a law to check the so-called frivolous PILs. Welcome back after the break. We are discussing the culture of PILs and judicial activism. Justice Verma, before you went to the break, we talked of some guidelines which are issued by the Supreme Court of India. Were these guidelines in place when you were serving or did these come into effect later?
Normally, this is correct. Whatever is being said now, the judge who is dealing with the PIL, that's always in his mind. One is, what is your status to do a thing? You are not doing it for your own personal thing, etc. Number 2, will it cause a public inconvenience or public benefit or public this and that? Those are always there. The only thing is that is in the mind. Now they are being written this and that. There is nothing new in it. PIL, the judges dealing with the PIL, they are already dealing with these type of guidelines. That is in their mind.
But can't we have some kind of a clear system, Justice Verma, because some Chief Justices, take very kindly to PIL, some don't. There's too much of, personal discretion of judges.
That's right. Normally they should not PIL, judge should be consistent wherever he is here or there. But if somewhere gets a personal attitude or personal inclinations, that cannot be helped. There of course there were many judges, many Chief Justices who were just name it a PIL, they will say no, without even hearing it also. Because normally it is put up before the judges, the senior most judges, and the Chief Justice is one of them. But some they were very receptive to it. Come and bring the cause to us. We'll help you. We'll help the public. It's not you're not helping a one petitioner.
But can't you have a uniform system for all this? Difficult.
PIL means is already uniform.
But as we are saying that some judges, some Chief Justices, they take very kindly to PIL, some others don't.
No, Supreme. It is an individual approach. It is not a judicial approach.
I don't think these personal choices or personal interpretation should be contained through regulation. Partially it seems that sometimes it does help, uniformly. But I would go by with the Justice Verma that let us trust our judges. Even if some personal predilection towards certain interpretation of certain pleas or certain PILs.
You have to leave it to the judge.
Exactly, because we have to trust
judge hearing it.
We have to trust them.
Professor Manjeet Singh, there is also a feeling that the government is bringing this legislation because there is a public perception that the government is unresponsive. Could that be the reason why it is bringing about such a legislation?
Unresponsive to?
Unresponsive to the people's aspirations.
PIL is only because of the reason the government is unresponsive.
That everybody knows. Otherwise, there is no need for PIL because government is unresponsive to the people. as our young fellow he has told that even in America, because we have a large number of people who are illiterate, backward, still living in, so that's why somebody has to represent them in the courts, and courts have to judge whether they are being represented or some ulterior purpose. I think that's why it's very, very important, and this space, civil society space or the people's space, if government want to usurp that, I think that's very dangerous move.
Very dangerous move.
Professor Manjeet
Yes.
has mentioned about America. In America, there's a lot, and you must be knowing it, there's a mass action litigation. If some person feels that some company, something has done this thing which is injurious to one person, and then this mass action takes place, everybody gets the compensation whosoever purchased that material.
The class action. So
That's a cross section. That's a cross section. It is not that we are, rather we are confining it only to a public action, public interest, where the general people are involved, where their grievances not being removed, so many other things. But they have gone advanced, much advanced than us. We are lagging behind.
Right. Mr. Arora, the government is also bringing about what is called the national litigation policy, because it feels that there is a huge pendency of cases and PILs are adding to this pendency.
Actually, national litigation policy is just a lip service. Government is not very serious. As I have told you about a study in Punjab, about 40% criminal cases under certain sections are being totally false and fake. These X-rays are procured and cases are filed. And under criminal law, I am surprised there may be some justification for not imposing a fine. You file a false case, it is dismissed, it is not proved beyond doubt, no penalty. I have seen cases where a person filed 30-40 cases, similar cases, fraudulent cases.
Mr.
No
Arora, the
punishment.
government is taking certain steps. We all know that they are asking the government lawyers to explain whenever they are seeking adjournments.
This is always there. Sometimes they are strict, then they relax, again strict. This goes on. They are never serious. This is what I know of the government. I have been a government counsel for 5 years. I was senior standing counsel. I know they are never serious about this.
Justice Verma, what else needs to be done to check the pendency of cases? Because I think this is one of the pleas of the government that, the PILs are adding to the pendency.
According to me, we cannot just attribute delay to one party or the other party. It is the conviction of a judge. If he is to dispose of the case, then whatever is on the record, he should go ahead with it. It is so in all the countries also. Why we accommodate for adjournments, this may like this. The case should be put up before the judge when it is completed in all terms. And the time, if suppose some time fact is given to them, okay, it is to be completed by petitioner in 6 months and another assessment. If they are not it, let it go to the judge. Judge should decide it this way or that way. People should suffer or bear the consequences of the same. But again, if we have the cases in the list, pending cases of 86, 87, 85, they are still not being decided. If they are on the list, then I can't say we blame the advocates, we blame the system, which system has taken a note itself. No, litigation means nothing, it is a luxury.
Justice Verma, coming back to the PILs, some people feel that a lot of advocates file PILs for the sake of publicity. And some of the judges also, they say, revel in this kind of publicity.
About judges I cannot say it, but of the advocates I do. There are certain organizations, name I will not say, some international such etc. through such an advocate. They do file it.
Mr. Arora, will you like to react to that? Some advocates actually file PILs for publicity,
Actually,
but it's not true of the judges, he
advocates
says.
are also human beings. These days they are also proactive. They are also in the campaigns for eradication of corruption, and PIL is one of the means for eradicating corruption and punishing the corrupt and the officials who misuse their powers. If they come in the forefront, there is nothing wrong in it. I may tell you about the perception of the judges about advocates about 20 years ago or 15 years ago. If an advocate would file an PIL, the judge would ask him in the open court, have you no other work? So they were so allergic to it. Now they are at least appreciating that we are doing something for the society.
But it's same is true, sir, about other cases as well, about civil cases. There are so many. You go for justice, but we know how the justice is managed in the courts. Evidences are
Well, how justice is managed in the courts, that's the subject of a separate discussion. Mr. Rametra, many feel that the courts are there to decide the point of law. And public issues are not something that the court should be deciding. You know, the public issues should be deciding through the electoral system. What is your opinion?
But how do you approach your elected representatives? They're sitting in their ivory towers. The power is so
But
centralized.
they come back to you, Mr. Amitra, every 5 years to seek votes. So that is the time you take it up with them.
So that's a short span of 1 month and then you forget. We all know the fault of our representative democracy now. And for a poor man who has no access to this, and for people who are living in the hinterland, in the rural areas, I think yes, there was a time when judicial activism perhaps did go overboard, but that was just a brief time. I think if we look at the last 20-25 years, it has brought great reprieve and great justice to the suffering masses.
Justice Verma, in your opinion, is judicial activism the need of the hour these days?
I think so, yes, especially in the present scenario, where what type of executive we have got it, what type of police we have got it, what type of even the subordinate judicial system we have got it. The honest activism of the university, they have saved the nation, they have helped the nation and the public also. It is necessary, but it is the need of the time.
Professor Manjeet Singh, do you think today the government is trying to curb the PILs and tomorrow it could even bring about a law to check judicial activism? Is there a danger?
Not only that, even RTI. I mean,
but the government itself has brought in the RTI.
yeah, that's what they can do. That there was a move to even contain that, and people opposed it, and they have stopped it. I think this is again, I will repeat that the public spaces where public voices are, are given to be aired, that should not be. Pendency is not only due to these. I mean, there are a large number of other cases which are never decided, are never attended to. So pendency is why only pendency due to wherever the public interests are involved. I think that is unfair.
Mr. Mitra, your experience having worked in Rajasthan of the RTI, is that being increasingly used by the common people?
Oh yes, yes, yes. In fact, RTI movement was spearheaded by Aruna Roy and Nikhil Dey in that area, and it's amazing how the common folk, the villagers, have used it, to find out what has the expenses been on health, what has the expenses been on the school, and they regularly participate in the social audits of NREGA regularly and expose corruption. We took out a Mazdoor Haq Yatra in 60 villages, and then we did a dharna in Jaipur. We found in some areas, in Tonk for example, some workers of NREGA had been paid just 1 rupee a day, and then they made a representation to the CM, and they sent those funds for the CM relief fund. Finally the government woke up and acted, but yes, that region of Rajasthan, very, very active, very, very proactive.
Otherwise the government was not knowing if the man is being paid only 1 rupee per day. This is the government, we have got it.
Absolutely.
Then somebody has to come forward to say it.
Mr. Arora, since we are running out of time, the last word from you. If you think the PILs are curbed today, will gradually judicial activism also go?
It is actually an attack on judicial activism. Under the garb of curbing PILs, they are trying to check the judges. Otherwise, once the judges have laid down guidelines. How come
the judges are not protesting? They seem to be encouraging the legislation.
They appreciate also. I may tell you, in one of my PILs, 5 police officers were removed. One of them went to Supreme Court. I appeared there in person. The Honorable Bench appreciated me in open public that you are doing a very good cause. We appreciate it. But sometimes, due to some case, some personal interest of some petitioner may be there, and they are annoyed also. They made off the cuff remarks like this also. It doesn't mean they are totally against PILs.
Right. Thank you very much for joining us in the discussion. PILs have come to be an important tool for bringing public issues to the fore. However, of late there have been instances of this tool being misused. But instead of bringing a law to prevent the misuse of public interest litigations, it is being widely felt, and almost all members of the panel here also agree, that this discretion should be left to the law courts. With this, we end today's Prime. We meet again tomorrow with another issue. Till then, good luck and goodbye.